Here we are, and it's really my pleasure to be speaking with you and with Louise, and to introduce Louise, who's been such an inspiration to so many of us. She's very bashful and modest in many ways, so I just want to. I'm going to be bestowing some accolades on you, Louise, and you're just going to have to bear it, okay?
Well, pay well for these comments, Art.
There are so many of us who have worked with and for Louise and continue to be admirers of Louise. She's launched innumerable successful careers. I just started, I know I'm going to miss a number, but I was just writing down a few. George Riley, who was Steve Jobs' personal attorney, and if you read the book, you'll see George is in the book. Gene Frazier is executive director at the Presidio. George Shell, who was general counsel for both Coca-Cola and I think the Athletic A's, and now he's general counsel at the Presidio. Jack Bear, who was a deputy who helped Louise and her team keep the Giants in San Francisco, and then he was subsequently hired by the Giants, and he's now general counsel to the Giants. And if you're familiar with the installation out in center field at what is it now? Oracle Park? I can never keep track. I guess it's Oracle Park. There's a baseball glove, and that is actually modeled after Jack Bear's grandfather's actual baseball glove. And I don't know how many federal and state judges it is. I mean, I think that I gave up trying to list them, but there's just so many. So this presentation is we're all lucky to be part of this and lucky to know and learn from Louise. I want this to be interactive. So if anyone has a question, we're not going to wait till the end like we have in some of these presentations. You can raise your hand, and then Madeline will let us know if you have a question as we're going to go along through Louise's kind of career and highlight some of the past things that she's accomplished, but also some of the current things that the firm and she and members of the firm are working on. To start, I thought I would go back and ask Louise to recount some of an earlier part of her career. I, by the way, was hired by Louise in 1987 and worked in the office for 9 years, worked closely with John, but also Louise on a number of different projects. But before then, Louise, you were a member of the Attorney General's office, and then you were elected to the Board of Supervisors in San Francisco. Tell us about your experience, if you will, on the board of supervisors in San Francisco.
Well, Art, if that question ties in with the very beginning of this program when Buck Delventhal's remarks were related about Dan White and what happened at City Hall. I had been involved in politics, but not local politics. I had been head of California Women Lawyers and running the Rose Bird campaign in 1978 when the assassinations came. And so Diane Feinstein, who became the mayor, appointed me to take her place on the Board of Supervisors. And truth be told, I had never been in the Board of Supervisors chambers before I was appointed, because as a deputy attorney general, I had been suing San Francisco. So I had been in the chambers. So the first meeting, the newspapers reported that Supervisor Renne was very quiet, at which point my father said, "That won't last long."
What was the process by which Diane Feinstein became mayor then? Because Mayor Moscone was the mayor, and then yes, he was assassinated.
He was assassinated.
Yeah.
And the way the charter works is that whoever is president, at least it did at that time, whoever is president automatically becomes the interim mayor. and that was Diane Feinstein. But then to become the permanent mayor, you have to get the 6 votes needed, and Diane had rounded up the votes. And so she not only appointed me to the board, but she appointed Harry Britt, who was a gay member, very active in the gay community, to Harvey Milk's place, and then another supervisor, Don Haranzi, to take Dan White's place. So she was responsible for appointing 3 supervisors, but these were very tumultuous times. We had riots after the acquittal, if you will, of Dan White. So we probably spend a lot of time talking about those days, but it was very interesting being on the board of supervisors, and I thoroughly enjoyed it.
So at some point you became city attorney, and how did that come about?
Well, I was on the board of supervisors when the city attorney, George Agnos, died. And I remember I got a phone call that I think our family, as I recall, we were in Europe on a summer vacation with the kids, and I got a phone call that George Agnos had died. And Diane then appointed me to be the city attorney for San Francisco. And if you go back in history, Diane was the first woman mayor of San Francisco, and she appointed me. I was the first woman city attorney for San Francisco.
And was that just an appointment that required board approval, or what was the political process for that, or the legal process?
No, well, the city attorney is an elected official in San Francisco. It's one of the things that's very unique about the San Francisco City Attorney's Office. There are only, let's see, of all the city attorneys in the state of California, there are only 3 that are elected. San Francisco, LA, and I think San Diego. And so when Diane appointed me, then I had to stand for election as city attorney. And as I recall, I think it was about three elections that I stood for as city attorney.
And I remember one of the aspects of being a city attorney in San Francisco is that unlike other employees who have civil service protection, city attorneys are at will, expressly under the charter. So whenever Louise was going through a contested election, everybody would be, kind of walking on, eggshells around you, because it was, if you lost, then our jobs were all in jeopardy because electeds could come in and sort of.
But as you'll recall, Art, I had a rule. I did not want the deputies to get involved in the election.
Yeah, I remember you were very ethical about it.
Very clear, because I thought
you never asked anybody for any money, and I can tell you that there are other electeds in San Francisco who didn't follow that rule.
No, I'm sure. I might just say to the group that while we're talking about the city attorney's office, that the San Francisco City Attorney's Office is different in many respects. First, because San Francisco is a city and county, and secondly, because of the wide range of clients that the city attorney represents, ranging from literally the airport that's in San Mateo County to the zoo. And I think it's about 2 years ago, I wrote an article for the Golden Gate Law Review about the city attorney's office, how it is unique, and some of the different cases and forces, if you will, that bear upon how a city attorney's office operates in San Francisco. I don't have the citation at my fingertips, but it was the Golden Gate University Law Review, I think 2 years ago.
Right, and I think what we can do perhaps is have, if that wasn't on the reading list, we could have Madeline find that citation and distribute it to the fellows, because that's an interesting part. Sums things up quite nicely.
Yeah. Now, if you're interested in municipal law or government law, I think that the San Francisco City Attorney's Office really is unique in the country, even compared to New York or Chicago, frankly.
So as I understand the history here, George Agnos and his predecessors essentially ran the office as a kind of a municipal law office where you would process claims, and you would, obviously there's transactional work that the city would do also, but in terms of litigation, you would primarily be an insurance defense company working for a municipal corporation. Is that right? And then I think, as I understand it, you kind of turned things around, and kind of a light bulb went off to the extent that you're thinking, hey, why do we have to sit back on our hands all the time? Why can't we actually affirmatively litigate and make change?
Yes, in fairness to city attorneys and county councils everywhere, you're right. Generally, what the primary charge of the office was always viewed to provide the advice, whether it was the mayor or the board of supervisors or city council, and to defend the city when sued. That was the primary job. That was the primary goal. And when John Holtzman came into the office, he and some others, I give John the credit here, started raising the issue of why wouldn't the city attorney's office be more affirmative in taking a look at wrongs, if you will, that were going into the city, whether there were taxpayer issues or consumer issues or what. And so the more I thought about it, I thought he is absolutely correct. So lo and behold, shortly after this conversation, I had gotten a phone call from a person who was actually then president of the Bar Association, complaining about the Olympic Club not admitting women or persons of color.
We should pause there, because I don't know that the fellows all know the Olympic Club. How many of you are golfers? Raise your hand. The Olympic Club is a very renowned golf course in San Francisco, and it has, had long been looked at as being one of the premier clubs and courses in the United States, if not around the world. So it was kind of a big deal. And so, sorry to cut you off, Louise, but then what happened then? I mean,
well, no, but that's a very important point. I mean, the Olympic Club was viewed as an icon. And so as we looked into it, we discovered that the Olympic Club, you play golf on 18 holes, and 3 of the holes of the Olympic Club were on public land. So I
owned by San Francisco.
Owned by the city and county of San Francisco. So I called the Olympic Club and said, y'all are not, you're discriminating against women and persons of color in your membership policies, and you're using public land. And so I think you should change your membership policies. Well, there was quite the uproar.
No, I remember that the leverage was, I think, unless you change things, Olympic Club, are you going to be okay with a 15-hole golf course?
Well, that is exactly what we said. He said, you have a choice. You can either play on 15 holes or you can start changing your membership policies. Well, it ended up, we ended up going short of court, but it was very bitter contested. And they finally said that they would change their policies, and they did. And so I think that after that, other clubs changed their policies too. But my poor husband was the one who really suffered most, because he had been a member of the Olympic Club, and people were so angry at me, they took it out on him. And in fact, one of his good friends went to his grave without ever speaking to Paul again. That's how bitter it was at that time.
Yeah.
On the plus side of things, some of the men who had opposed it, some years later would call me to say, thank you, my daughter is now a member of the Olympic Club.
It was, I don't know if I ever told you this story, but my office was right next to George Riley, and George Riley was handling that case.
Yes.
And forget the swearing and epithets that came out of George's office one day when who was the firm that was it Roper's Majeski or something?
Yes, it was.
They were trying to just do the bombastic thing where they gave George the stack of litigation papers, and I remember hearing him just swearing up and down and slamming the papers down. So, and on a side note, then, and just I think I know the answer to this, but I want your view. I mean, you've got the Bohemian Club, which is still all male, and they run up to the redwoods on the Russian River and cavort by themselves, and they have the downtown facility. You remember Jerry Spain was the musician. Jerry was one of Louise's deputies. He took me to lunch there one time. He was not a wealthy man, but you could get into the Bohemian Club if you could play an instrument, and you had that talent. He played the cello. Right.
Well, there's some private organizations you can't change, but what has happened, other clubs, I mean, like the British Open, others are now open to women and persons of color. But, you can do some things, and then some things you can't, and you try to do what you can.
Right. So, turning to another case, which was of interest, is tobacco. And tell us about that. I mean, what led you to that issue, and then how did that play itself out, and what happened?
Well, in San Francisco at the University of California, UCSF, there is Dr. Stanton Glantz, who is a renowned expert in tobacco and tobacco use and the impact tobacco has on the health of people. And he and some others, another woman and some folks came to visit me one day, and they said, these were the days that we had the Joe Camel ads, the Marlboro Man, all these ads that were used to get young people to smoke. And once they started smoking, they would become hooked and become addicted and go on. So they presented me with enough evidence to demonstrate that there was a direct correlation and effort on the part of big tobacco to hook young people to smoke through these ads. So we filed a lawsuit, first against Reynolds and Company, to prove that they were hiding the evidence. They were sending a lot of it over to Europe to hide. And we were able to prove that indeed they were targeting young people to get them to smoke through these ads. And there were some hearings in Congress on the subject. And while that lawsuit was going on, one of the state attorney generals, interestingly enough, in Mississippi, had brought a lawsuit against big tobacco, not only claiming about the ads, but that in general, big tobacco was harming the health of individuals. So we filed, our California Attorney General would not get involved, but we had a coalition of other cities and counties in California that we filed a second lawsuit against big tobacco. And we could prove damages in San Francisco on the basis that we have public hospitals. We have not only San Francisco General, but we had Laguna Honda, and we could prove damages. So we actually had settled the Joe Camel case when it all became part of what became a master tobacco settlement, which was reached in the halls of Congress on the part of all states, because by then most of the states could see big money at the end of the road that the tobacco companies were going to have to pay for the damages. And so there were big settlement negotiations in Washington, D.C., and all of the states signed on to what's the Master Tobacco Agreement. And in the Master Tobacco Agreement, ads like Joe Camel were stopped. There was to be no smoking in movies or television. There was a certain amount set aside for education, and then the rest was a lot of money to all of the states. In California, we were unique because half of the proceeds went to local governments because we were the ones who had sued. The California State Attorney General didn't come on until the end. And the irony about all of this is most of the monies that came from the Master Tobacco Agreement did not go toward health needs. In California, for example, Wall Street came in, they made a proposal to take the stream of money and with it pay off California's debt, whatever their deficit was at the time, and then they would keep the revenue stream. And in San Francisco, I am glad to say we did otherwise. We took the money, and we're talking at this point, $300 million just at that point, to rebuild the Laguna Honda Hospital, which is one of the few skilled nursing hospitals in the United States. And then as the money has continued to flow in, it has been used to rebuild San Francisco General Hospital. And so some of that money is still coming in, but keep the fact that how the money was used in the Master Tobacco Agreement to the side, because later in this discussion, I'm going to come back to that.
And then I have one other case that I wanted to ask you about. It involves the Bank of America. What was going on with the Bank of America, and what caused you to take on that large institution?
Well, we had a whistleblower come in. Actually, I'll tell you what, I was at a cocktail party, and a lawyer that I knew came up to me and said, Louise, I am representing a whistleblower and we would like to come and talk to you. So I said, fine, come on in. So they came in, and lo and behold, he was a Bank of America employee who said, you know, the Bank of America is taking public money and keeping it to themselves. Not only San Francisco, but all public agencies. And what they were doing was, at the end of the day, the money is all put in what's known as a sweep account. And interest is paid because the money is invested during the night and interest based. They're earning money on it. And so what the bank was doing was taking all of the money, both private and public, putting it into their own account, taking all of the interest and income, and then moving it back in the morning. And so, you know, all the public agencies, we were losing money that otherwise belonged to us. So we did a little investigation, and I will never forget, in that case, we got hold of an email where this problem was pointed out, to which the response was, well, let's let sleeping dogs lie. So they weren't going to tell us about it. So needless to say, we won that lawsuit.
So you've gone off and formed your own law firm, and the first, I think you became you were partners with John, and then you formed the Rennie Sloan firm. When you first joined with John, I remember I was with Myers Nave, chair of the Labor and Employment Group, and I remember meeting with you, trying to get you to come to our firm, and couldn't get you on board at that time. I think there was a revolving door problem in the charter, because you had conferred. So you had me handle some cases. Speaking of house cleaning, one of the interesting cases that Louise gave me in private practice is when Terrence Hallinan was elected district attorney. Speaking of cleaning house, he came in and fired 14 deputies, like within the first week, and that spawned litigation, which I was happy to handle. He was a character. Terrence was a character. Yeah. But let's pivot to sort of what you and other members of the firm are working on now. And there's something going on in the United States, and even I think beyond the United States, involving opioid addiction. Right. And are you involved with that? And how are you involved in what's going on with that?
Right. Well, I'm sure everybody has been reading about the overdoses, the opioid overdoses. And in California, of course, we've had our problems just like everybody else, West Virginia, Ohio, et cetera, you name it. And so there are about 3,000 local government cases against Big Pharma. And I'm using not only the manufacturers like the Purdue, but also distributors, McKesson, some of the other CVS, Walgreens, all of whom have been involved, frankly, either in lying about the addictive nature of the opioids and or distributing, turning a blind eye to how many pills they are selling, which are obviously being sold improperly, to put it mildly. So where you have a large number of cases like this, and we're like in a coalition, if you will, with some other law firms representing a number of California cities and counties. But where you have this number of lawsuits in federal district court, they are put into what's known as a multi-district, or MDL, multi-district litigation. And in this case, all of the local government cases have been put into a federal district court in Cleveland, in which the district court judge is Dan Polster. I will say he is one of the finest district court judges I have ever appeared before. He has made it clear that he wants these cases handled sooner rather than later. And frankly, I think this case would be over, but for the coronavirus, which has interrupted, for the most part, all negotiations, et cetera. But be that as it may, Judge Polster has put all of these cases, and what happens in an MDL setting too is that the judge will designate certain cases to be a bellwether case. And a bellwether case means that it is a case where it's before a court, another federal district court, and the evidence presented is pretty much what it would be the evidence in any other court, so that it shows what would happen if 3,000 cases were tried. So right now there are bellwether cases. I think there's one in Florida with an Indian tribe. There's been one in Ohio, there's been one in West Virginia, and now in San Francisco. And so San Francisco, which we represent, is now a bellwether case. We're before Judge Breyer here in San Francisco. So while the trial stuff is going on, behind the scenes, there are some negotiations that are going on. It's already been reported in the paper that Purdue, which is Sackler family, and frankly, there must be a special place in hell for them because of the way they lied, have been put into bankruptcy. Now, immediately people think, oh, that's terrible because they'll just go away. Well, the unique thing about this is Purdue and the Sackler family and their interests are all being put into bankruptcy with the idea that a new corporation is going to be formed. And the new corporation will have all of the patents on opioids, because you continue to need pain medicine for cancer, surgeries, that sort of thing. You can't eliminate it. That would be a bad thing. You can try to control it. And the other interesting thing is, you may read in the paper how if somebody is about to die of an overdose, the police will give them a shot of Narcan or something to overcome the overdose. Well, guess who owns that patent? Purdue. So out of this bankruptcy, the goal is to have both of the patents under a new corporation, new trustees, all under the auspices of the court. So that's all going on, and sort of in the mix in all of this is the state attorney generals have decided to get quite active now. And so we'll see how that is all going to play out, with the state attorney generals wanting to do, for the most part, their own thing. But meanwhile, you have the cities and counties where the real hurt is. And so that is all in the process of being sorted out as I speak.
And if I have this right, actually, you were appointed by the court to be one of the key players on the settlement committee, which is a big deal. I mean, you're modestly not mentioning that, but.
Well, it's a very interesting concept. Judge Polster came up with the theory that trying to get a settlement is often difficult when you have so many players. So he established a concept of a negotiating committee. And the negotiating committee would be responsible for all negotiations. Now, the defendants and the negotiation committee consists of the three primary plaintiffs' lawyers, the Corporation Counsel in New York, the city attorney in Chicago, and me. And it's been complicated by the fact that the defendants have filed an appeal to the Sixth Circuit on the whole concept because it's the first time something like this has been tried. I'm expecting a decision any day on that.
I was going to ask you what the status of that is. That's just sort of been fully.
Well, we actually expected a decision at least a month ago, but again, you know, the coronavirus has just put everything back. So
right.
I don't know if I could get on an airplane now anyhow, so hate to say it.
Yeah.
So it's interesting as an aside to everybody. It is interesting how many settlement negotiations are being undertaken through Zoom now. Very interesting. It's a whole new way of doing settlements, a whole new way.
And I have a couple of few matters coming up where it's all Zoom, including depositions and even an arbitration coming up. So, which is a whole different topic because it's complicated to deal with the exhibits and there's a lot of discussion about strategy and how to do that and how do you assess somebody's credibility over a camera. It's just different. So another case, you took on this tiny little company called Google. Why don't you can you enlighten us as to what that case is about, or is it? I think it's in a sensitive stage right now. So, what can you tell us about that case and
well,
what's
everybody might remember? Hard to believe it's a year and a half, maybe almost 2 years ago, where a lot of the employees at Google walked out. They had a gigantic walkout because a number of their very high profile executives had been asked to leave, but under circumstances where they were paid millions of dollars, in one case $90 million, even though it was clear that they had sexually harassed and otherwise acted inappropriately in the workplace. There's not even a question about it. But so finally, when the facts became so clear and so well known, Google had the executives leave, but only after substantial payouts. I say $40 million, $90 million. And of course, you had a general counsel, et cetera, that his then wife was asked to leave, but not him. Anyhow, there was a big employee walkout. And it's very clear that there's been a culture, not only at Google, but throughout Silicon Valley, of sexual harassment toward women, lack of diversity, et cetera. All of these were part of the complaints. And so we filed a shareholders lawsuit, which oftentimes shareholders lawsuits can raise the public interest questions. And so we have filed a shareholders lawsuit against Alphabet, that's the holding company. Since then, of course, more executives have left. And I anticipate that there will be something in the news one of these days with regard to the case, but I just can't say anything more at this point.
Okay.
I'll just say this one little funny thing though. My one grandson called me one day and he said, "Grandma, did you really sue Google?" Funny. He was impressed by that.
So, you know, I have this other case involving tobacco again with the Juul company. I mean, what's wrong with Juul? I mean, it's smokeless tobacco. Isn't that better for you?
No, unfortunately, you know, I have a friend in New York who actually is head of Parents Against Vaping. And she came to San Francisco and with some other folks I know. And we were able to determine that it's just like big tobacco. What Juul did, and we have all the social media. Juul went and on all the social media targeting young kids. They literally took a playbook out of the tobacco scene. And we have clear evidence that they were targeting kids to get them to vape with impact. You know, once you start vaping, pretty soon you do get addicted. I don't care what. So far, the evidence we have is that. And so, again, there have been a number of lawsuits filed all against the country. In this case, we're representing a number of school districts because school districts are impacted by vaping. First of all, kids are vaping in the bathroom. Secondly, they're not paying attention to their studies. And so there are a number of impacts like that. Again, because there are so many lawsuits, they have been formed into another MDL proceeding. And this MDL proceeding is before Judge Orrick in San Francisco.
Okay.
You know, while we're on this, I did forget one thing on the opioid related to tobacco, that and Judge Polster has made it very clear that when and if there is a settlement in the opioid case, he does not want it to be like big tobacco, the master tobacco agreement, where the proceeds did not go to, in this case, it would be drug health issues. He has made it clear that when and if there is a settlement that comes before his court, it will have to make sure that the money goes directly to the problem. And frankly, in the opioid case, the problem is so severe, we will never have enough money, in my opinion, but we might make a little bit of a dent in the issue. Yeah, I forgot to mention that before.
Yeah, it sort of reminds me when my kids went to Berkeley High School, and the kids started going to these hookah parties where they would smoke this stuff. Does anybody know the name of what that is? It's like shisha or something like that you would put in there. And I had this conversation with them. I said, you know, nicotine is one of the most addictive substances around, and what the hell are you doing? You know? And they said, there's no nicotine in this stuff. And so I went to Whelan Smoke Shop on Bancroft, and they had a whole wall of shisha. And I said, can I see some of the shisha? And sure enough, it has nicotine in it.
Yes, it does.
And so maybe that's another angle we can think about, because somehow they're promoting this idea that there's no nicotine in this product, and it's just not true.
It isn't true. That there may not be tobacco, but what they've done is they've made salts, and there is nicotine in it. In fact, there's more in a vape than a pack of cigarettes. And now the biggest thing is there's another group that's come out after Juul. Altria, which is big tobacco, of course, has over 30% interest in Juul. Juul is moving from San Francisco to Washington, D.C. I wonder why. And the other big thing is Puff Bar has now become so popular with the kids. And so that is probably going to be involved in all of this.
Well, that reminds me, actually, because you, I remember, I think the old firm, at some point, you were taking on an issue involving what you called alcopop, which is the, you know, kind of the sparkling beverages that I believe, in talking to John, were being marketed again to teenagers and teenage girls in particular.
Yeah.
As being the new kind of drink. What was that case about? What happened with that? I never.
That case was ultimately settled, as I recall, Art. That case was ultimately settled, yeah.
Okay. Well, with that, we have about, and I'm going to try to keep to the time schedule today because we're putting everybody over and there's a lot on everybody's plate. But so we have about 20 minutes left. And if anyone has questions, this is a fabulous opportunity, I think, to be able to ask Louise directly what's on your mind.
Hi, thanks for taking the time to talk with us today and for this great program. I was curious, you spoke about this a little bit when you talked about the state AGs getting involved, but what your perspective on the difference between affirmative litigation at the city or county level and at the state level, and just what the differences are, or advantages or disadvantages at either level?
Well, I would always appreciate that if a state attorney general gets involved, that they would move aggressively. Unfortunately, what's often happened is that the cities and counties have moved more quickly. Now, it may differ state by state, and some of the state attorney generals are far more aggressive in trying to address a problem than others. And a state attorney general obviously has the power to move on behalf of the whole state. In California, it's somewhat unique for the San Francisco attorney general to have roughly the same power. I think it's best when the cities and counties and the state can work together collectively and cooperatively. It makes much more difference. Sometimes when it gets down to it, it may be, if it's stopping the practice, that's one thing, but other times it may get down to the allocation of the money. And so, for example, in the drug cases, the fact of the matter is that most of the money needed to address the opioid problems, for example, is needed at the county level. And because the counties, for the most part, control where the health dollars go. But that may very well be an issue. But your question is a good one, and it's more recently the state attorney generals have been more active, which I think is a good thing. But the overall need will be cooperation on both the local and the state level. That is going to be the key. Thanks for that. That's a good question. Yeah.
Thanks so much for sharing. This has been incredibly interesting. My question concerns way back when you were transforming at the San Francisco City Attorney, you're transforming this traditionally defense-oriented practice of municipal law and creating this pioneering affirmative litigation program. Did you receive any pushback during this transition? Were there voices saying, hey, stay in your lane, or not? I guess I'm just curious, were there any special challenges as you kind of pioneered this new approach?
No, I don't think there were many challenges. One of the practical considerations is, and one of the practical reasons why I think city attorneys' offices for so long were unable to do anything is because, as Art and John and anybody could tell you, the caseload that deputies have is daunting. I mean, the number of cases you have are daunting. And to do an affirmative litigation case, you literally have to take time away from that. So one of the ways I solved that problem was to set up a special affirmative litigation section. And their sole job was to go ahead and focus on those cases so they didn't have to worry about missing a deadline or something on a case and defending the city. I frequently got charged with being very political because of these cases that I was bringing, and I suppose I was, but I think most people, let me put it this way, I kept getting reelected, so I must have been doing something right.
I would add, I think, Louise, you were able to deal with the budget in a way that you could fund your office, and you were able to secure funding and increase the number of attorneys in the office so that you could alleviate the concern about, having too many cases. I mean, and it's so true. You, as a deputy, say on the trial team, you could have dozens and dozens and dozens of cases, and it's both exciting, but on the other hand, for those of us who like to dive deep on a case, you can't do it on these, on these big cases unless you have a lighter caseload. Louise, by the way, was nice enough. I don't know if you remember, Louise, when we won that case, the Stewart case, which was we challenged federal regulations under the Fair Labor Standards Act as being arbitrary and capricious, and managed to get a win out of Judge Legg. But again, you were able to allow me and the team to focus on a big case and not be distracted by dozens and dozens of other cases. And I got to go back to Washington, D.C., and thanks to you, Louise, and actually lobby members of Congress to make changes because those regulations were really stupid, and it was a fun outcome.
I will say this, that when sometimes opportunities come along, and when you are in a position to do something about it, it's a good thing to do. For example, the office was very involved with domestic partners, was sort of the first step towards same-sex marriages, and domestic partners was highly controversial. That when the board passed it, we were sued. United Airlines sued us. And
Just so you know, the fellows had an in-depth presentation on this whole thing by Dennis earlier today.
Okay, good. All right, good, because that's an example. And the other kinds of cases that we had early on, where we had police discrimination, fire discrimination cases, where you had to come up with remedies, consent decrees, et cetera, to deal with them. So there are a lot of very important public policy issues that do come up. No question about it.
Can I tell the story about Food Not Bombs?
I'm not sure I remember, but go ahead.
So at one point, 4 years into being in the office, I decided, hey, this labor and employment stuff is okay, but I want to do something a little different. Louise, what do you have? And she gave me there was, at that time, there was a big homeless problem, even back then, and people were camping and in front of City Hall, and the plaza looked much different then. There were trees and places where people could actually, effectively live in the bushes. And then there was this organization called Food Not Bombs that was setting up essentially a soup kitchen in front of, right under the mayor's balcony, and feeding homeless people. So I was given the job of shutting that operation down, because they were not only, which creates this sort of ethical, dilemma, because, how can you rationalize shutting down an organization that gives away free food? Well, the reality is that they weren't really shutting it down. They were simply letting people, they were simply asking them to get a permit from the health department, because you can't have a homeless population with health risks all reaching into the same container of food at a lower temperature and so forth. There were a number of different health risks, and this organization had they were just being anarchists, essentially. They didn't really, I don't think giving away food was the whole idea. But I managed to bring the leader of the group up on contempt charges and brought him into Superior Court. And at that time, Superior Court was one floor up from your office, our offices, Louise, in City Hall. And I was the sole deputy with, I think 200 people who supported Food Not Bombs sitting at the table, and they were, throwing spitballs at me and hissing at me. And then the judge read them the riot act, and then I left. And then the police, in their infinite wisdom, decided, hey, this is a good time to arrest Keith McHenry on an outstanding warrant. So all hell broke out in City Hall, and essentially started a near riot, because these people were yelling and marching through City Hall, and they came to the mayor's office, and then our office is on the right. And I you were there, and you said you came in and you locked the city attorney's office door and said, Art, why don't you take the rest of the day off? I never asked for another project outside of my lane after that experience. But anyway, I'm taking up time.
Hi, Louise. Thank you for being with us. It's so fascinating to hear about your career. My question was, what was your impetus for switching from the city attorney's office to private practice? You know, for those of us who are interested in local government, there seems to be two, you know, obvious paths, such as working for the local government or doing this private firm work. So, you know, sometimes they say private firms, they're better access to resources. So is it kind of more of those traditional reasons or something else?
Well, for very personal reasons, Kelly. One of my daughters is married to a person who's in the shipping container business, and they were moving to Europe and with the grandchildren, and they were going to be there for the next several years. And I just realized as city attorney, I would not be able to just take off and go to Europe every time I wanted to see the grandchildren. So I decided that I wouldn't run again because I thought, well, you know, I wanted to see my grandchildren. At the time, I thought, well, what I really wanted to do then was to run a foundation. But what happened was that the new head of the San Francisco Unified School District called me and said, you know, Louise, we have real corruption going on here in the district. Will you come and be our general counsel? So making it clear that I could go to Europe to see my grandchildren, I ended up going to the school district, setting up an office for them. They did have real corruption. In fact, a number of people went to prison. We sued one of the companies and got millions of dollars for the school district to get it back. And then I decided, well, that's when John was going to be leaving the mayor's office, and we decided we would set up our own law firm. So that's the story on that. Yeah.
Great. Thank you for speaking with us this afternoon, Louise. Following on Kelly's question, what of RPLG's accomplishments are you most proud of? And what do you hope to accomplish with the firm as it continues to develop?
Well, that's a good question, Michael. I think one of the things that I'd like to think that makes us all special, if you will, is the commitment to public interest and public service. I think every one of the lawyers, I can say without fear of contradiction, is ethically right on top of things. They're very interested in doing well and doing good. And I think and we're very collaborative. If there's a hierarchy, it's certainly passed me by. I just do what I'm told. But I think everybody kind of walks around when we can be in the office. But going forward, I think what we would like to bring, we would really like to make sure that we have high quality, good lawyers in the office that are interested in public interest, public service, working for the greater good. And I think it was somebody earlier who said, more than ever, we need people that who are intelligent and well-motivated to be involved, whether it's in the public sector or the private sector, working on the issues of the day in a positive way. And Michael, if my memory is right, you're working on voting rights issues now?
Yes, that's right.
As I recall. And I actually thought about you yesterday because of the Georgia election and what all is going on there. I actually know one of the candidates. She didn't win, but I followed that election with keen interest. And so I thought about you, and I thought Michael was working on voting rights. Oh, we really need to move forward on that. So,
yeah, we're getting involved in that case. It should be.
Oh, you are. Good. Well, I don't know if there's anything you think we can do. We're pretty busy right now, but I think that we're very interested in that. So, but we're really looking forward to having people join the firm who are as well motivated and willing to work hard to serve the public interest. That's what we're all about. And we have some fun along the way too. I think we need people with a good sense of humor too. That's important.
Yeah, I think that's actually on all of our job postings we've ever put out, is that a sense of humor is one of the
Key criteria.
required qualifications. Okay, Peter.
Hi, Louise. Thank you as well for this
Hello,
really
Peter.
engaging talk.
Yeah.
Since you worked on big tobacco and opioid, big pharma, and seen different way that these settlements can shake out, I was wondering if you had thoughts on the litigation against carbon companies and climate change, and whether you think some combination of the more political congressional settlement or the more judicially managed trust process might be politically or legally possible and wise.
Well, I think carbon climate change lawsuits are going to be very critical. I mean, unless and until we have a massive change in the political structure of the federal government, it may be that court lawsuits are the only way to handle the situation, which would be a shame, because I think personally it takes both court cases and political will to make the fundamental change that we need. My hope is, and maybe this is not right, but my hope is that maybe with the coronavirus, that people will start to realize how important science is, because if the science of how we deal with this is something I think people haven't even thought about. And so my hope is that it will be a combination of lawsuits as well as political change, because there's no question in my mind that climate change is very real. I've been sort of watching the lawsuit brought by the young people, the kids, if you will, in federal court to see how that's going to go. So the more that can be done, I think the better. Well, it's critical. I mean, you all are of an age where it's going to affect you far more than me. And that's what I say to my grandchildren too. Look, you're the ones who are going to be affected by this. By the way, Peter, I think your interest in transportation is quite of interest. And I think that that is going how transportation is handled in the future, obviously, is going to be tied into climate change, and how transportation is handled, particularly with the coronavirus, is going to be interesting to see how you can solve people being together and yet getting people out of their cars. Very challenging.
And now you've got people going back into their cars, right? Because who wants to take BART into the city?
Well, some people cannot. Yeah. Well, that's why I think working remotely is going to be really important and going to happen.
If we have time, I think Jake has a question if there's time for it, and then maybe we wrap up.
Well, it's up to you all.
Art, is that okay?
We've just got a few minutes. That's great.
Okay, so Jake, go for it, and then we'll wrap.
Sure. Just quickly, I had a question on, I think Tuesday we spoke to a group of city managers who talked kind of extensively about the line between having a political role in the city and sort of being a employee of the city, and as an elected official, which is, you already spoke on, is more unique. You have kind of a unique role, but I was wondering if you had any thoughts on, as maybe a deputy city attorney or other city attorneys, where you see that line for a city attorney as a sort of apolitical public servant, or something a little bit different.
Right. Well, I actually addressed that question in the article I wrote in the Golden Gate Law Review, but I always try to be very careful When it came to giving political advice, when it came to giving legal advice, I was very careful that I did not give political advice. I gave, and I had our deputies very clear that as lawyers, we give advice. Now, if we are asked our opinion about a matter, we can offer our opinion, but I was very clear that the advice that we were giving or how we were handling litigation was strictly by the book, if you will. Often when it came to matters, then the Board of Supervisors or the mayor would have input as to the directions that they wanted, and we followed it. But I tried to be very careful separating what I did politically from what I did as a lawyer for the city. And I think the deputies have been, to a person, careful about this as well.
And I would also, Jacob, save that question for tomorrow's session on the role of the city attorney, because it's actually on the list of items that we're going to talk about, is where that line is and whether they feel comfortable crossing it. So you can ask Teresa and Louise. We've got Harvey Levine from Fremont. He's going to be on the panel.
Can I just jump in, Jay? I will get a little political here. I do not agree with the role that the present Attorney General Barr is playing in a number of these cases. I shouldn't get political, but that's...
You didn't think he should have walked across the square and cleared out the demonstrators and posed in front of that church with the Bible?
No. No, I think, to me, that literally crossed the line.
Well, Louise, thank you again for taking the time.
My pleasure. Thank you, everybody, for listening.
Thank you again, Louise, and thank you to the fellows and everyone participating. I always learn something new from you when I do one of these with you. So, thank you.